Okay, we're ready to begin. Professor David, you are ready? Good afternoon, everybody. Welcome to this afternoon's presentation. It is my pleasure to introduce to you Professor Judge Dennis Davis, who probably needs very little introduction to a lot of people. Professor Davis was appointed a judge of the High Court in 1998 and as president of the Competition Appeal Court in 2000. Since his appointment to the bench, he has continued to teach constitutional law and tax law at UCT, where he is an honorary professor of law. He is a member of the Commission of Inquiry into the Tax Structure of South Africa and was a technical advisor to the Constitutional Assembly, where the negotiations for South Africa's interim and final constitutions were formulated and concluded. He hosted a television program, Future Imperfect, which was an award-winning current affairs program between 1993 and 1998. He is a visiting lecturer professor at the universities of Cambridge, Florida, Toronto, and Harvard. And he also teaches at Wits University and UCT Stock. Over to you, Professor Davis.
Thank you very much, Zulega, and good afternoon to everybody. Let me try to sketch what I'm going to do in the time available to me. I want to talk a little bit about constitutional democracy and its future in general. It seems to me perfectly obvious that we should be doing that now in the light of what happened in the United States quite recently and the clear fragility which the world has experienced with regard to the model of constitutional democracy, which is the one we chose to have as our governance structure back in 1994. I want to then, if I may, move on to apply some of those insights to South Africa in general. And then I do want to say quite a bit about the present situation thanks to COVID-19 and what it is or is not doing with regard to those of us who are concerned with the rule of law, with constitutional democracy, and the future of democratic society in South Africa. Sorry, if people could mute, it would be very helpful, because I'm getting quite a lot of noise. Let me start then, just make some general observations about constitutional democracy. If you read the political science literature over recent times, the argument generally is that constitutional democracy reached its global highlight in the period between 2006 and 2011, and that subsequent thereto has been in dramatic decline, which is the cause of considerable concern. It is due, perhaps, this particular tendency to what has been referred to as defective democracies, regimes that retain formal constitutional institutional trappings, but flout the norms and values on which any constitutional democracy has to be predicated. And so it's not a case so much of constitutional democracies actually being destroyed as being eroded as such. We can see that in perhaps the most clarion terms by looking at the failure of the Arab Spring movement of 2011, Egypt reverting to military rule, Libya, Yemen, Syria descending into increasing levels of armed conflict and brutal repression, the political repression which has deepened in all of the Gulf states, are perhaps the most high-profile instances of what I'm talking about. But perhaps more disturbing for South Africa, more disturbing for those of us who are worried about the future of constitutional democracy in South Africa, is the case of the decline of those countries that emerged into a constitutional moment at roughly the same time that we did. I have in mind in particular Hungary and Poland. I also think about the growing electoral success of nationalist parties, such as the National Front in France, the Alternative for Deutschland in Germany, and the Freiheitliche Partei in Austria. we have also seen significant constitutional erosion thanks to the influence of religious fundamentalism in countries like Turkey and India, and by the rise of authoritarian presidential figures like Maduro in Venezuela, Duterte in the Philippines, and Trump in the United States in 2016 and Bolsonaro in Brazil in 2018. Let us be honest about it, that we've had a not dissimilar situation, although not quite as drastic, in South Africa, and I'll come back to that, which is that notwithstanding the remarkable success that we had, lifting ourselves almost unaided into constitutional reality back in '94, we've seen a sense erosion of a regime of accountable multi-party democracy, and I think it would be fair to say we're in a lot more trouble now than we would have been predicted, say, 20 years ago. So we've now got a situation whereby, in fact, even in academic literature, there's a burgeoning literature with regard to the present constitutional state of affairs. Let me refer you, for example, those of you interested, to a book by Mark Graeber, 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 and Sanford Levinson, Levinson, and Mark Tushnet, Tushnet, Constitutional Democracy in Crisis, 38 chapters, which reveal precisely the point that I've been seeking to make. Let me also say that if we drill down to the United States of America, there can be little doubt that when you've got 74 million people voting for Donald Trump, who clearly embodies everything which is an antithesis of constitutional democracy, you realize that even a country which has had more than 200 years of democratic rule can in fact have a model which is far more fragile than otherwise would be the case. And so what I'm trying to do just to start with is to settle a framework. I mean, it is also true that developments in the United Kingdom, the xenophobia which exploded thanks to Brexit, the attacks on the judiciary by the Johnson government, and a serious apprehension of where this all leads to in terms of either the unification or fabrication of the United Kingdom, is another example of the fact that, if you want to put it bluntly, we are not alone in facing this particular threat. So that's by way of starters. Let me then refer you again to another book which some of you may be interested in, and which is very well worth reading, by Levitsky, Levitsky, and Ziblatt, Ziblatt, Levitsky and Ziblatt. It is called How Democracies Die, and it was published in 2018 by two Harvard political scientists. And may I suggest to those of you who are interested that this is a very fine text to have a look at much of what I'm talking about. So again, I'm at the global level. I'm going to drill down slowly, if I may. They make two sets of points that I'd like to share with you this afternoon. The first is they set out what they regard as the 4 warning signs, which you have to take account of if you're concerned about the democratic health of your country. In other words, if you want to take, as it were, a constitutional temperature to test whether the country's got sort of constitutional COVID, the first thing you do is to have a look for these 4 warning signs. And what are these warning signs? Firstly, there's the rejection of the democratic rules of the game. The idea that a very significant portion of the country rejects the democratic rules of the game. So if you look at the United States as an example, the idea that a most significant part of the Republican Party, against any and all evidence, rejects a freely conducted election and believes in the false narrative of Donald Trump is an example of the rejection of the democratic rules of the game. You can't have that. And it really is, it's all very well that Joe Biden got in and that America survived what was obviously a critical moment. But if you are concerned about the health of democratic society, you have to ask yourself, how widespread is this rejection of the democratic rule of the game? How widespread, to take another example, would there be a disregard for the output of legitimate court structures in a society? And I'll come back to South Africa in this regard in a moment. Secondly, second warning sign, a denial of the legitimacy of political opponents. The idea that the political opponent has absolutely no legitimacy, that the political opponent represents in the postmodernist lexicon the other, that the political opponent represents everything which is antithetical to the nationalist project and therefore has no legitimacy to speak and is nothing more than a lunatic fringe which undermines the very Weltanschauung of the society in which the politics is located. Thirdly, the toleration or encouragement of violence. The idea that violent conduct, the kind of conduct we saw a couple of weeks ago in Washington, the encouragement of that by the then President of the United States of America, the idea that violence is in fact a means by which people, as it were, can vindicate their genuine genuine political aspirations, is scary, frightening, and deeply disturbing. And one has to worry about that too. And then finally, a willingness to curtail civil liberties of opponents, including the media, a sustained attack on the independent media, the promulgation of fake news, the idea that civil liberties of some must be curtailed at the expense of some particular political project which prefers some over others. So what Levitsky and Ziblatt are saying, if you look at these are indicia, these are indications of the kind of tendencies which ultimately will lead, if not to the death of democracy, to its erosion. And if you go back to many of the countries that I've been speaking about, Hungary, which started life off as a very promising constitutional system with a very fine constitutional court, Poland the same, Turkey at some point the same, Brazil exactly the same, India prior to Modi in exactly the same way. All of these countries, through a range of different characteristics, now exhibit some or all of these warning signs, and that is deeply disturbing. Then the question that they raise, if I can make one final point on this before moving on. They say that if you are going to have a constitutionally democratic order, there are two core questions, two core norms that have to be complied with, that have to be adhered to. And these are they. Market toleration or the mutual toleration, or the understanding that competing parties accept one another as legitimate rivals, that there is a legitimate contest, different perspectives, and that there is some toleration between the parties. They may not agree, they may have vastly different views, but they tolerate each other, and there is at least some acceptance that the other is a legitimate rival. And the secondary forbearance, which means that politicians should exercise restraint in deploying their institutional prerogatives. They shouldn't, in fact, seek to exercise legal powers that intentionally privilege one group over another, which to a large degree seek to discriminate against targeted groups, or alternatively ensure, like for example, the United States of America in the previous Obama administration, when the Republican Party refused to even consider the legitimate nomination of Merrick Garland to the Supreme Court of the United States. All of these factors, if you can't have some form of mutual tolerance, if you can't have some restraint in which you see that public power has to be exercised for a public purpose and not for a nefarious purpose, that's a serious problem. And that's the kind of problem that you can't possibly have in the situation which prevails under a constitutional democracy. So now, with these particular insights in mind, let us have a look at South Africa in the year 2021 as we move further into the COVID pandemic and ask ourselves, in the light of what has occurred over a period of time, how confident can we be that the questions I've posed, that the tendencies that I've highlighted in other parts of the world are not particularly, why I'm getting a feedback on my, are not particularly different here to what they are in the comparative analysis to which I've briefly engaged. So let's start with the South African context. Perhaps the way to start, if I could ask Lerato to put the one slide on that I've got, just to illustrate something to you, and we'll take it from there. Lerato, if you could help me. Lerato?
Yeah, he is there. Don't worry. It just takes a minute.
Great. Okay, thank you. So what I've got on the board for you, friends, is just two observations from the evidence that Dr. Sidney Mufamadi, who is the chair of the high-level panel looking at state security in South Africa, the evidence that he gave to the Zondo Commission recently. The first little quote there in the smaller typing is a little quote I've taken from the affidavit to which he deposed at the hearing. The key finding of the panel was there been a serious politicization and factionalization of the intelligence community over the past decade or more based on factions in the ruling party, resulting in an almost complete disregard for the Constitution, policy, legislation, other prescripts. He's saying a serious politicization and factionalization of the intelligence community. Our civilian intelligence community was turned into a private resource to serve the political and personal interests of particular individuals. In addition, the panel identified a doctrinal shift towards a narrow state security orientation in the intelligence community in 2009, in contradiction to the doctrines outlined in the Constitution, White Paper on Intelligence, other prescripts. The panel expressed concern that the cumulative effect led to a deliberate repurposing of the SSA. Right? So that's the first quote. It comes from Dr. Mufamadi, it comes from his affidavit, and what he's pointing to is the way under the Zuma administration, for a decade, state security apparatuses, the intelligence community, were used to promote a factional interest in the ruling party, a complete disregard of constitutional precept and legislation, a private resource to serve the political and personal interests of particular individuals. That's number one. Let's have a look at the second quote, which comes from the evidence he gave before Zondo. State security has ominous connotations. It's anti-democratic. As a country, we cannot suddenly have forgotten where we have come from before 1994, where we have intelligence serves war techniques. Zuma's proclamation, besides usurping the role of the legislature, that's to set this whole institution up, created a situation which once more ran the risk of bringing the security establishment back into the cockpit of our political system, with the possibility to re-choreograph the theatre of wrong deeds that we saw in the past through either political partiality or the weaponization of the intelligence community for purposes other than those which the agency existed for. Dr. Mufamadi is telling us that in a similar fashion to the way in which a securocrat establishment in the 1980s under P.W. Botha ultimately reconstituted constituted South Africa as a securocrat country in which the security police and the military establishment ran the place for particular interests at the expense of the overwhelming number of the population, that you had, as it were, notional adherence to law and fundamental compliance with state security precepts. That's exactly what we've lived through in the past 10 years. Now, that's astounding. This is coming from Sidney Mifamadi, who I might just remind you was in Mandela's cabinet as a long-standing cadre of the United Democratic Front and ANC. We are not talking about somebody here who was in the political opposition. We are not talking about somebody here who's got some kind of apartheid gripe with the present regime. We've got somebody here who was central to the early governance structures when the ANC came into power in 1994. And these two quotes, and there are many, many more, surely must be a clarion call to us to kind of start thinking through how much of these warning signs to which I've made reference really continue to exist in South Africa. Continue further to think of what Dr. Mifamadi had to say. If he's correct, it appears that something like 2.5 to 3 million rand a month was squirreled through the bagman, Minister of Security, Horrible, to Jacob Zuma every month for his own pleasure. So if you work that out over a year, we're talking about something like 30 million rand, if not more. It boggles the mind. There are accusations in this particular evidence that independent newspapers, which is a really particularly interesting title for the newspapers under that stable, that some of the independent newspaper initiatives were projects of state security. Well, I don't need to remind you that that's how the Citizen began in the late 1970s, in a similar parallel structure. We are told that there may well have been, although it seems to be maybe 1 or 2 judges of whom money was allocated in order to ensure that they gave the right decisions, which means that even in the judiciary, it is possible that there has been the tentacles of state capture of the particular kind. And so when you read Dr. Mifamadi's evidence, we are talking about very, very serious questions. And they raise, I want to suggest to you, in the light of my general analysis, three questions that we have to ask ourselves, which is, firstly, is it such that if there are normative commitments which are foundational to any constitutional democracy, one of the ones that cannot be a normative commitment, that must be the exact opposite of a normative commitment, must be the pervasive evidence of rent capture and rent seeking. And in a country like South Africa, where we literally are battling to as it were, find the money necessary for vaccines and other absolute necessities, the idea that this could be happening with such largesse indicates that, in fact, one has to ask the question, were people in politics simply to pursue their own personal interests or the public interest? The second question that arises out of this is the ineptitude of the institutional structures which were designed as constitutional guardrails to be able to deal with the particular problem. And I'm going to come back to that in a moment. And then the third point that comes out of Mifamadi's evidence, and certainly must be uppermost in our minds, and in which we deserve to be discussing and should be discussing, is if this was true over the past decade, how much of this continues to operate in South Africa in the year 2021? To what extent can we have confidence that we've reached a point where, having descended into a nadir of rent-seeking, corruption, and perverse activity, we've come out on the other end with constitutional systems still intact and able to vindicate the foundational promises of the 1996 Constitution. Let me deal with the second and third points before moving on to apply this directly to COVID. It seems to me that in relation to the point that I made that Ziblatt and Levitsky make about the notion of forbearance, the use of institutions only for the public interest, we in South Africa, in a sense, failed that test ignominiously, thereby eviscerating one of the two foundational principles upon which any constitutional democracy can actually be predicated. In the first place, we know, and we continue to know, that key institutions which were designed to protect the South African public from the sort of perversity to which I've made reference were captured, were eroded, were eviscerated. A public protector's office, which under the heroic leadership of Thuli Modonsela became the entire antithesis thereof, and in a sense almost to the extent prompting the idea that the public had to be protected from the public protector. The second point was that we saw the National Prosecuting Authority almost destroyed without more, and is now battling to recover, to the extent that some people, not suggesting myself, but I'm just saying, if you only read the commentariat, some people are still bothering to argue, rightly so, as to whether we have the capacity to bring crooks to book. Thirdly, the same was true of SARS, although having worked closely with that institution under the new Commissioner Kieswetter, I'm hopeful that that institution, which is absolutely critical, not just to tax collection, but to probity in the public finance world, is beginning to change. We saw the police and the hawks become no more than the kind of instruments to which Dr. Mufamadi referred in the evidence, which you've got the two quotes on board. We saw, to a large degree, the media playing a very small role, except for heroic exceptions, the Daily Maverick, to some extent News 24, the Abu Ghani reporting methods, center, and a couple of other examples of publications, but that was about it. And thank goodness to them, we were able to find information and access kind of knowledge of a kind that we otherwise wouldn't have been able to do. So the institutions which were designed to deal with what was going on, and to which Dr. Mahdi has made reference, clearly failed entirely. But let us even go further than that. We were faced as well with a legislature which is one of the three central elements of the state in a constitutional structure, and which has as a major purpose the holding of the executive to account, failed in its tasks lamentably. And we've got to ask ourselves why. Now, I understand that Judge Zondo, in his typically careful and exhaustive manner in which he is going about the business of investigating state capture, is particularly interested in this particular question, and he's right to be. What was it about the institution of Parliament that has failed us so miserably over the past decade, if not more? Is it an inherent flaw in the structure of Parliament itself? That is, that we could actually be more innovative in the relation to way committees, etc., function? Or, as I would want to argue, and did so in the book I wrote with Michel Leroux, called Lawfare, Judging of Politics in South Africa, published in 2019, that in fact, foundational to this question is our electoral system. And here I'm not talking about one political party or another, I'm talking about the whole gamut. That if you have a list system in which the party bosses are entirely as it were, free to select who the lists of the parliamentarians are going to be and the representatives of the provincial councils, it is not surprising to me that there'd be huge reluctance to hold an executive accountable, because it's a very, very kind of career-limiting move. If you are such a parliamentarian, to say to hell with what the party bosses have to say, I must follow my conscience and the interests of my constituents, whom I don't really have because I'm on a list system. And it does seem to me as a matter of complete urgency that we are going to have to relook at what Van Zyl-Slabbert recommended many years ago in regard to a change in the electoral system, to see whether we can't bring the representatives closer to the people, so that the representatives feel more accountable to the people whom they serve than the party bosses who shape their careers. So those are crucial questions which have emerged out of the Mufamadi evidence, the state capture evidence, the saga of the past 10 years. I want to make another set of points with regard to the role of the judiciary, but I'm going to postpone that, if I may, although I see time marching on rather rapidly. And I did promise to only talk for 45 minutes. I don't think people's concentration spans are longer in these kind of hearings. But let me move on, and I'll come back to the judiciary in a moment. So I've given you a general analysis of the tendency of the health of constitutional democracy around the world. I've indicated the devastating effects that state capture and the kind of indications of the evidence that Dr. Mufamadi has offered to the Zondo Commission show as a light to our constitutional health or lack thereof. I want to talk a little about COVID and what comes after COVID. Let me make a claim, which some of you may disagree with, and some may agree with, but I'm offering it out as a point for discussion, and I'm offering it out as a point from somebody who, other than a few cases less, is effectively retired from the bench, but has spent the vast part of his career trying to conceive of how a non-racial, non-sexist constitutional democracy can flourish in South Africa. I want to suggest to you that what COVID-19 has done is to have reproduced, as it were, non-constitutional tendencies which have spread like wildfire through South Africa. Let me explain. We had a state of emergency declared, state of disaster, declared under the Disaster Management Act in March of last year. It is perfectly understandable that was done. It is perfectly understandable that the government was battling with a unique situation which all countries in the world were battling to sort of negotiate, and which had not occurred in 100 years. Let me also say, before moving on, that no country in the world has done particularly well here. Some have done better than others. It might be easier if you're a small island like New Zealand, a more flourishing society such as Australia, to deal with the problem. But you only have to look at Boris Johnson's UK, some of the countries in Europe, the disaster in the United States of America, to realize that, again, to quote something I said earlier, we are not alone in having to deal with the particular problem there is. But since March of last year, we have lived in a world in which the sort of command council has replaced all forms of government. We do not have a parliament that has actually been allowed to find out sufficient information so that the public can understand what the hell is going on. We seem to have a parallel structure of a sort of docile, somnambulant parliament, and then a command council which basically has, like a vacuum, has vacuumed up all the political power in the country. That has resulted in some profound erosions of the kind of principles which are equally important if we are to have constitutional democracy. There is very little accountability, and there's even less of transparency. Let me give a couple of examples that I'm talking about. If you look at the vaccine saga, it appears to me that almost every week the narrative changes. You know, how many vaccines are we going to get? Where are we getting the vaccines from? How is it that we're going to roll out a vaccine program for 40 million by December? Where is the transparent information? We told at one point that Johnson & Johnson have entered into an agreement with South Africa in which 300 million doses will be produced in South Africa. It then turns out that South Africa will be the sort of end part of the value chain in this particular connection, but that we are not entitled to the 300 million. We may be lucky to get some. We then sort of find out, well, we're supposed in the second quarter get COVAX, AstraZeneca. How much we do not know. Is this particular vaccine effective for the variant? Well, we do not know. We simply are clueless in this particular regard. When you read columnists like Peter Bruce saying that, in fact, he called Moderna, and Moderna claimed that they'd never had an approach from South Africa, even though one of their key people is an ex-South African, one wonders, how true is all of this? We simply do not know. How will the vaccine be rolled out? I'm not talking about the IT, but if you've got to wait 15 minutes after you're vaccinated, how are we going to be able to do this in sufficient numbers, and sufficient efficacy, and with sufficient social distancing? We have no idea. We have no idea beyond perhaps the first million doses, which perhaps if it's AstraZeneca, which we assume means it's going to cater for 500,000 health workers, which seems to be an inflated number, but again, I can't be sure about that. So we don't have any information of that particular kind. But it goes further. Think about the following. If you look at the Department of Health website, you will see that there were various advisories published from earlier last year, which indicates that somewhere along the line between between September last year and January of this year, negotiations were taking place with pharmaceutical companies in order to acquire vaccine. Now, I accept that there are difficulties about this. I share with the President of South Africa the horror of vaccine nationalism. I understand perfectly that people like the President are right to be furious with the notion that this is not seen as a public good, that in fact certain of the pharmaceutical companies are seeking to extract rent from us way beyond what they're prepared to impose on the EU or the UK. But here's the thing. I'm going to constitutional structure now. If, for example, we were negotiating in September for vaccines, did it not dawn on anybody that actually we had to work out how much this was all going to cost? And did it not occur, because we don't know, whether in fact a proper conversation took place at Cabinet, where Cabinet would have had a report from the Minister of Health, which would have said, yes, we're trying to acquire sufficient vaccine to ensure vaccines for 14 million people, and a question would have been asked how we would pay for it, and the Minister of Health would doubtless have said, well, that's not really my department, we've got X, we need Y. The Minister of Finance has to be informed, and that therefore right from the beginning in an ordinary cabinet discussion you'd assume that there would have been a decision taken as to broadly how to fund the thing, not scrabble around in January trying to tell us a whole different range of stories, which basically means that the constitutional structure of an executive run through a cabinet, accountable to a parliament that is able to have proper hearings and debate all these questions, really did not take place at all. Or seemingly it didn't take place. And if it did take place, we'd all like to know so that we could all understand. What is the story I'm telling you implying? It's implying that to a large degree, the very idea of a constitutional democratic structure in which the public are entitled to know, that they have a fundamental right to know, and that accountability to the public is absolutely central to any such enterprise, seem to be two principles which now, as it were, are distant cousins from reality, and they haven't met for years. And so what I'm really saying is that what COVID-19 and what the disaster management system has done is two things. Whilst the government understandably has massive difficulties, and I am the first to be sympathetic to it, the question which we have to ask is, are we now on a path which, when this COVID actually begins to lift, please God, because we can all be vaccinated, and let me say in parenthesis, I still find it extraordinary to believe that we're going to be able to vaccinate 40 million people by the end of the year. You only have to do the arithmetic to work out how much that has to be per day, since we're going to only start in the middle of next month. The question arises, is the legacy which has now been left one which is going to, as it were, indicate an increasing tendency, together with all the other developments to which I've made reference, an erosion, a result in an erosion of constitutional democracy, the kind of toleration, the kind of forbearance, which is absolutely essential. I do not know. And that brings me, finally, to the question, which is a really interesting debate, which is about the judiciary and its role in the preservation of constitutional democracy. Let me say something about that in general terms. I am the first to find the question of judicial review and the idea that you have a vibrant, independent judicial system absolutely crucial to everything I've been speaking about. And that what it is able to do, that is judicial review and a vibrant, brave judiciary, is essentially, as it were, to hold the line, to preserve principles of accountability and transparency, and to impose a doctrine of rationality on government decision-making. All of that is crucial, and all of that happened under the Zuma administration, to the great credit of the judiciary. It is, as I said many, many times, a source of great pride to me that my colleagues, drawn from the very kaleidoscope of South Africa throughout its breadth and depth, really rose to the occasion in a way that no judicial system in South Africa's history has ever done. And to those judges who gave all sorts of important judgments, we owe an enormous debt of gratitude. But if you drill down and ask yourself, what are the limitations of what the judiciary can do? The record which we have at present illustrates that quite interestingly. It tells us the following. When it comes to the question of setting aside irrational government policy, say, do it properly, judges do a fabulous job. That's part of their job. When it comes to questions of saying you can't evict people from homes, from even squatters who are entitled to access to housing, at least on a progressive basis, you can't allow the law to throw people, as it were, onto the veldt in the pouring rain without some attempt, some significant attempt, to ensure that they should at least be provided with the dignity of some housing. All of these, of course, can be underpinned by footnotes of various cases. You can't, as it were, just, as it were, replace the Scorpions, which was a very effective anti-corruption unit, with something which is totally and utterly representative of Pavlov's dog, that is the minister's dog, and can do only what the minister suggests. That, again, is where the judiciary come into, and the judiciary can assert the importance of fighting against corruption as part of our constitutional enterprise. It is also true you can't appoint incompetent people who are disqualified from high public office just because you say so, without taking account of what the law suggests. But it's very hard to see the judiciary doing much more than that. If you're asking the judiciary to, as it were, reconstitute the state so that it serves 60 million people, hard to see without more how the judiciary does that. If you look at the socio-economic rights cases in South Africa, many of them have prevented, fantastic cases that they are. Some have insisted on ensuring that schools provide children with meals. That too is something that was done. The most classic case of where the judiciary was able to step into the breach was in the HIV case, where it was the ideological blindness of the government of the time which refused to provide antiretroviral drugs to all who needed it, save in certain select target areas. But if it is something which goes beyond that, where you are really asking a government to respond to massive social ills, to, as it were, ensure that funds are available, to ensure that you have a tax collection system that works, a legislature which operates properly, a vaccine policy, not what of course you can say which is rational, that the courts can do, but actually ensures that it actually delivers to 40 million, even in circumstances where we have a right to health. If you do not have a state that is capable, if you do not have a state that can deliver the 40 million doses to 40 million people, if you don't have the institutions of state that can actually fulfill adequate public administration purposes, there is a limit to what the courts can do, however commendable they are. And so what I'm saying by way of conclusion to everyone is I believe that what happened over the Zuma period is not just part of history, that COVID-19 has in effect brought about almost an exacerbation of the challenges which we posed before it came into being. And if that wasn't enough, the fact that we have an official unemployment rate of over 30%, official, that we have growing inequality, and that if you look at the growth projections for South Africa going forward, the most optimistic would be 3.6% this year, but that surely has to be over the top in the light of the fact that absent a vaccine, we're not going to get the economy going fully and efficiently. And that then predicts 2.5% in 2022. I should remind you, neither of which figure will address the levels of unemployment, generate sufficient tax revenue to reconstruct our society, even with the best will in the world. So the upshot to this is, where are we as a result of COVID-19? In deep, deep trouble. And we need to start actually asking us, answering the questions that I've posed, if we are going to get out of this mess, both by a decisive economic recovery, not through talk, but through implementation, through a reconstitution of the structures of government, the legislature, to some extent the executive, and to a large degree, the re-implementation of the principles of accountability and transparency, and the eschewing of command councils in favor of representative democracy as soon as possible. And I'll leave it there. I'm very happy to take any questions, comments, observations, and criticisms that people wish to offer.
There's one hand up.
Oh, good. Do
Alex,
I just look? Yeah.
Okay.
Please ask. Alex.
Good afternoon, Judge. Nice to have you address us in the way that you have, always confident. I'm intrigued with your I'm intrigued with your confidence in the judicial. Can you hear me?
Yes, I can.
I'm intrigued with your confidence in the matter of judicial review, but surely as an but surely judicial review has been shown to be of a somewhat paraplegic nature when you come to look at the way in which the judges themselves have been involved with the matter of the Schlope case. That's been going on ad nauseum. Where's the judicial review shown to be effective there?
It's a great question, Alex, and it's not one that redounds to the credit of the judicial institution. I can only hope that in the light of the fact that finally last month we had a comprehensive hearing into the initial complaint, which has gone on forever, as you rightly say, that the tribunal which heard the matter and which reserved judgment before the end of last year will bring forth its judgment or its ruling ASAP, and finally will bring certainty to the matter. But you are dead right. If you want to ask a question which flows from this, i.e., if I could ask a question and pose it back, not so much to you, but just as a reflective, rhetorical question, I think what your question reveals is again a really interesting point about whether the Judicial Service Commission, as it's presently constituted, plays an effective role in holding the judiciary accountable. And if you really want to know my opinion, no, the answer is it hasn't. Now, it may well be that a clear and careful judgment, one way or the other, let me make that absolutely clear. It's not for me to decide how that tribunal will come down, but a clear and comprehensive judgment from the tribunal which sets out the facts and allows us to say, well, we may not agree with the outcome, but that's a rational, plausible, and clearly justifiable conclusion, will help us move on. But I do think we need to have a broader debate. There's been lots of criticism for a long time about the appointment of judges, particularly at the higher level, and the Judicial Service Commission's function. There is and has always been a view that perhaps we should have less parliamentarians or politicians on the council, and perhaps more people drawn from the ranks of civil society. I can see no reason why the religious community, established religious community, or the trade union movement, or fundamental sectors of the non-governmental sector should not be on the Judicial Service Commission, to give a balance and diversity of opinion without such vested interests, which all politicians have one way or another. So we should be having a debate about that. That is another structure. You know, in defense of that structure, when you start off and you think about it back in the 90s, you do the best you can and you can't predict everything. But I think it would now be right to say it hasn't worked fully, and if we were honest with ourselves, we should rethink it. So your point is well made. I cannot agree with you more, but I await with interest, as I dare say you do, the judgment of Judge Labuskaghni and his colleagues in the other case.
Thank you.
I see there's a hand up from KB.
The mute and the camera.
Kate, you can pose your question.
This little thing.
You can show your face if you want to, then we can see who you are.
It's always nice to see the person.
Kate, go ahead. I'm not sure if you can hear us.
Hands up. Has she indicated anything by way of text? No.
What conditions do you think will have to be in place for the rule by the Command Council to come to an end and us to revert to the semblance of parliamentary democracy that we have, where we don't have a constituency system?
Well, I mean, at some point, of course, the minister has to have that extended, every particular period, because it can't be indefinite, but it has become almost the permanence for the temporary. There, and there are only three ways and that can be done. Either the minister, which is I think Minister Zuma, of course, Dlamini Zuma, decides that we can go back to parliamentary democracy. Number two, I presume that that a party or any interested party could go to court and say it is now way beyond the limitations of the Act, and therefore the continuous decision to do this is irrational. And that's difficult for courts to do. As I keep on saying, when it comes to COVID type cases, it's very hard for courts to second guess experts. If you get an affidavit from a significant virologist who says this pandemic is still unpredictable in all sorts of ways, this is the best way to manage it, this is our predictions for the next 6 months, hard for courts to say to hell with this, let's get back to Parliament. But the third, I think, which is the most important, is that Parliament should reconvene. I mean, there's got to be a State of the Nation address, presumably next month. And I would hope that whether remotely and presumably remotely, because COVID is still around in rather frightening numbers, that Parliament actually debates this fully, and that the public then hears what is the justification for sidelining Parliament. And the kind of questions that I've posed, which are in a sense apolitical, they're not designed to score points for one party against another, but they're designed to extract information which we, the public, are entitled to. I'm just absolutely sick and tired of literally opening up a webinar or listening to the experts that the government appoints. And let me just say something about that, if I may, because I'd forgotten. It's interesting to me, listening to Dr. Fauci, that he suggested that that he and Dr. Birx were sidelined by Drs. Atlas and Dr. Nabarro by Donald Trump because they spoke, science. I find it really interesting, although I don't for one moment suggest that any of the advisors advising government are hacks in the way that Dr. Atlas and Dr. Nabarro were. But it does seem to me rather strange, to put it mildly, and I'd love some answers to these questions, as to why, according to all my medical colleagues and all of the literature in relation to who is the most distinguished and who has published the most scientific data on this, and who knows more about this particular pandemic than anybody else, why Professor Glenda Gray, the president of the Medical Research Council, and Professor Shabir Mahdi, the dean of the Faculty of Medicine at Wits, and who's an absolute respiratory expert, who are widely acknowledged as being the two finest experts we have in this particular field, play no role at all in the formulation of scientific evidence which is presented. And that seems to me the kind of sets of questions that I'd like parliamentarians to ask, because I'm entitled, as are you, to an answer as to why are the best people not being inspanned in this moment of pandemic.
Alex, have you got another question, or is it an old hand? I see your hand is still up. Kate, do you mind taking down your hand?
No, she's very welcome to ask.
Yes. No. Oh, sorry. She can ask her if she has another question.
Yeah.
I don't see anything in the chat. Lorata, did you pick up anything in the chat? Richard.
Sessions, yeah. Richard?
Hello, Judge. A wonderful talk. Thank you very much. With your comments about the Van Zyl Commission of Inquiry into Electoral Systems, I agree fully, but tell me, is there any practical way of getting it implemented if the government just plain says no?
The answer is no. There is no plain way. But Richard, the real reason one does these talks is because it seems to me we want to be. There was a point in time in South Africa, a marvelous point, it seemed to me, after 1990, when the country became one big political seminar, and all of us, black, white, pink, green, blue, women, men, no matter one's sexual orientation, we all participated in vigorous and wonderful debates about the trajectory of our country. And the best we can do is all kind of keep these ideas alive. And the answer is no, we can't do it unless the government does. But there seems to be no reason why there shouldn't be a more sustained set of debates about whether the present electoral system is actually conducive to a viable doctrine of separation of powers, or is it not? And I am encouraged, enormously encouraged, by the information I received, which is reliable, that Judge Zondo quite correctly is equally anxious about why it was that the legislature failed so ignominiously, and could it possibly be that he will now take steps, as I understand he's taking, to perhaps, as part of his report, make some observations, recommendations, not necessarily on the Slubbert Commission, but given his views and the views of the experts that he will have taken into account, in perhaps, given as a Judicial Commission inquiry, promote the kind of debate I'm talking about.
Okay, well, that sounds encouraging. Thanks.
Pleasure.
Lerato, are there any comments or questions in the chat? I don't see any. I don't see any other hands.
Oh.
AA, there's a hand. AA.
Yeah, one more, yeah. We'll take it with pleasure.
I'm not quite sure who AA is. Maybe you can use your
Yeah, Alex, carry on. Carry on, Alex.
Once again, Judge, on the matter of what was happening in America, we were constantly warned of the fact that certain politicians were guilty of hate speech. And that was, there was some form of constitutional means of saying this person is guilty of hate speech. Why is there not that concept in America?
Oh, it's a good question, because the Americans have a much more fundamentalist idea of freedom of speech than we do, thanks to their First Amendment. In other words, there's this idea of no abridgment of freedom of speech. And in a very famous case called Brandenburg versus Ohio, the idea was it was only speech where you sort of shout fire in a crowded cinema, in other words, we really threaten somebody in a direct way, or their lives and liberty, that in fact free speech can be curtailed. So the Americans have battled for a very long time with the idea that where does freedom of speech end, and let's say hate speech begin? They have not had the kind of crafted constitutional instrument that we have, or Germany, etc. So their jurisprudence is a complete mess in this regard. You're quite right. And one of the things about, well, it's going to be very interesting because we await in South Africa a really interesting case dealing with the late John Kwalani. You may remember he uttered what I think everybody accepts as awful homophobic speech. And the question was whether our legislation was so poorly drafted that in fact it trenches upon freedom of expression. But we will be getting a judgment of that soon. But there's no doubt in South Africa, the kind of thing that was said by many politicians, absolutely outrageous, racist, anti-Semitic, sexist language, that would be problematic in South Africa.
Yeah.
But not